Hello and welcome back to Coin Lady channel. I thought you would find this exchange between a former SEC attorney and some members of the XRP community interesting, so I thought I'd share a snippet with you. Look, I've said it before and I'll say it again, I'm convinced this is the case. Any lawyer currently employed by the Securities and Exchange Commission (SEC) will, without fail, follow the agency's lead. If they comment at all, they would undoubtedly state that the SEC's charges about Ripple and their implications for XRP investors are accurate. However, if you can find a former SEC employee who is ready to talk on the subject, they will probably challenge the SEC's approach. However, this does not imply that they all are. Here we have someone who used to work for the Securities and Exchange Commission as an attorney. I think he may show me incorrect based on what I've observed. But this SEC lawyer is being intellectually forthright, in my opinion. What's more intriguing is that despite his solid belief that Ripple broke the law by not registering XRP, this lawyer believes that Ripple has a decent chance of winning their case against the SEC in court. So, I'll give you a taste of the debate and explain the current line of thinking. But he's mistaken about this and that when it comes to claims on secondary markets. I like that even though Twitter has traditionally been a cesspool, it's wonderful to know that I'm not the only one that appreciates this, just watching the back and forth and, seeing a community's members share their ideas. The XRP community calls that area home, so it's quite great. That's why I'm on Twitter when I otherwise wouldn't be. However, there is something I need to make clear before we go any further. I have zero experience in either the law or finance. Nothing I say or write should be taken as legal or financial advice, and you should not make any purchases or sales based on it. For fun and as a pastime, I enjoy making videos about crypto-related topics to share on YouTube. Okay, then? Check out this headline on the SEC and Ripple in the world of crypto. Respectfully interact with the former SEC official, top attorney advises XRP holders. That is the proper way to go about it. Assuming the other person is being intellectually honest in their disagreement, there's really no reason to go ballistic over this. That's something you should save for the trolls, especially the cottage cheese-loving variety, if you know what I mean. Anyway, this is what the following says. Bill Morgan, a distinguished Australian lawyer, expresses his desire that the XRP community opt for civility. In rebuttal to claims made by former SEC attorney Mark Magel that Ripple had broken Section 5 of the U.S. Securities Act. To be clear, Section 5 mandates SEC registration for any and all issuers of non-exempt securities. Magel has been making charges that Ripple broke the law by selling XRP, which he calls an unregistered security, for the past week. The attorney for the SEC also claims that the securities watchdog has a stronger summary judgment argument than Ripple does. Also, let this be noted. I find that ridiculous, but he has the right to his own opinion. The aim of this movie is not to debate the merits of an attorney's analysis, John Deaton, in my opinion, though. Therefore, I will not subject myself to that again. But he has put out the case extremely thoroughly and meticulously. Why? The SEC's summary judgment is so poorly drafted that the judge is almost certain to rule against them. That doesn't rule out the possibility of narrow victories, though. However, winning the case on summary judgment alone is unlikely to result in a positive outcome. No war has broken out. Furthermore, Fragile stated that the SEC's claim that Ripple violated Section 5 of the Securities Act is accurate, based on his 3 decades of expertise as a lawyer for and against the SEC. You know what else? Maybe you could convince me if you stuck to specific transactions, especially in the beginning. Maybe in that case. However, the SEC's approach has proved absurd, as it asserts that all past, present, and future transactions are illegal because they have not been registered with the government. That's just not true. And that is just what the SEC claims. This has no basis in the law whatsoever. But in any case, consider this guy's own words. After 30 years practicing law for and against the SEC, I have come to the conclusion that the SEC is in the right. That Ripple broke Clause 5 of the agreement, end quote. However, he's not overly certain that the SEC will prevail. Even while he agrees with the SEC's assessment, he does not appear to believe that this is the most likely outcome. Because of the dispersed nature of Twitter conversations, keeping track of them can quickly become a Herculean task. Therefore, I will not revisit the beginning of this discussion. Nevertheless, I see no need to do so in order to get to the heart of the matter, which is the topic I wish to address in this video. I'm going to skip ahead to the next section of the dialogue. Member of the XRP community Stephen Huber provided a clip of Representative Patrick McHenry. This occurred at the hearing where he had previously questioned Kim Jong-Gensler. You might remember. Gensler, to some extent, it was enjoyable to watch. To put it simply, Gensler, never before have I seen him seem so uneasy. His whole body was trembling. His hand was out of his control. This actual trembling. So anxious was he. Of course he's nervous. Because he is such a horrible person, I take great pleasure in watching him face the music. Simply put, he's not intellectually honest in any way. Let's argue for his desired outcome or outcomes. So, people were talking about that video over there. As a result, Stephen Huber commented, so simple to mock. Yeah. One day he walks in and starts chatting with Mark. The former SEC lawyer replies, yeah, one day you will look back and realize what you are now witnessing. Since Madoff, this is the biggest financial scandal in the United States. Now, Attorney Farrell stepped in to respond to Stephen Huber of the XRP community, and he wrote what follows. You mean crypto? He asks. Yes, I also think so. I am relieved that some effort is being made to counteract the massive crypto hoax, even though the road to this solution was winding. You can tell this person is not a crypto supporter because of his or her general attitude that cryptocurrencies are pointless. Nothing could be further from the truth. You know, it's all just a series of scams. It's not that none exist. Scams can be expected, of course. Con artists operate. And obviously relevant to any legitimate economic sector or investment entity. We should all agree that such things are terrible and work together to counter them. It's nice to have common ground like that. But if that's all people are thinking about, they're losing a huge opportunity and a pivotal period in human history to adapt to the revolutionary changes brought about by cryptocurrency and the way it's transforming the world and the way value is transferred throughout the globe. I strongly disagree with him on that point. Krypton, now here's a name. In response to Attorney Fitzgerald's claims that cryptocurrency is a massive Ponzi scheme, Krypton Avenger asked, why did the SEC have a note on the XRP ledger? And you may have forgotten or overlooked it, but the SEC was in session. If there's still an active XRP ledger node, I'm unaware of it. I don't recall whether or not it was a validator. Possible only a node was involved. In a nutshell, they hired a business to do it for them. But that's much worse, since it means spending more tax money on something that will inevitably be inflated if they aren't doing it themselves. And so, I know it's utterly crazy and outrageous to use public funds to operate a node to process transactions that the SEC claims are illegal, but it's a true thing that happened. The SEC actually did that, so yes. I know, right? Boom. This is a legitimate. The Southeastern Conference is us. Let's take part already. It appears that was their line of reasoning. The truth is that I don't know when they were doing it, but it may have been before they decided to assault Ripple and steal all of that XRP for themselves. All deals are illegal because they involve securities that haven't been registered for sale. That could explain why we're having issues. However, in response, Attorney Fitzgerald replied, I'm not talking about ledger technology. I'm referring to fraudulent and unregistered securities sales. Let's halt there for the time being. He's completely misinformed, as XRP is used in every single transaction. That's the initial application of XRP. DDoS protection charge method on the XRP blockchain. So it appears he does not understand that it involves more than just ledgers. All of it requires XRP in particular. My guess is that he is unaware of that. Attorney Farrell then asks whether or not the SEC issued public securities. Did the SEC use an unregulated stock market to steal from investors? Here's where Cash, a member of the XRP community, steps in. And unless Judge Torres rules that Ripple offered an unregistered security, he continues, all your remarks indicate nothing but your bias, your lack of knowledge, or both. This means that up until this point in time, Ripple has never offered unregistered securities. From a technical standpoint, that is correct as well. That is certainly the case. The SEC has admitted as much. When it comes to the veracity of their claims, the SEC emphasizes that the courts, not the agency, have the final say. It is therefore a statement of truth that Ripple has not been found guilty of such a charge up to this moment. That means they haven't taken that step as of yet. Until judgment is entered, an SEC lawsuit is merely an allegation, Attorney Farrell retorts to cash in. That's why I avoided saying the obvious. On summary judgment, I go with the SEC, but everyone is waiting to see what the judge decides. A reply that says, "Thank you for being so forthright, but your earlier tweets show, not as opinion, but as fact, that Ripple has already supplied an unregistered security. If you're claiming that it's simply your viewpoint, then that's fine with us." And then the lawyer responds, "I don't know how I could suggest it's a fact when there is no court ruling. My 30 years of experience as a lawyer representing clients before and against the SEC have led me to the conclusion that the SEC is in the right. That Ripple broke Rule 5 of the agreement. However, a different outcome from the court would not surprise me." There you have it. He's under the distinct impression that, all things considered, Ripple may yet emerge triumphant from this ordeal. They might be on the verge of a major breakthrough. Plus, I'm not sure. I'll be honest and say that I'm in the dark. Because secondary market transactions have nothing to do with anything Ripple was doing or any scheme that Judge Torres might find Ripple to be involved in, I'm optimistic that there will be a way forward for XRP holders in the United States. So, I have a more positive outlook on that. Nonetheless, I do not rule out the possibility of violations, Judge Torres, penalties for a certain transaction. That's not impossible by any means. That's something that will really annoy me. If that's the case, it's because the SEC didn't point to any particular deals, which may include anything and everything that's ever happened before and will happen in the future. It's just ridiculous. This is the position, however. Another member of the community called Dan replied to Attorney Farrell by asking, would this not need to be proven in instances? That excerpt is included below. Surely it cannot be said that all sales of XRP by Ripple constitute a securities offering. It seems impossible to me that a purchase of XRP from a total stranger on an exchange could pass all 4 conditions of the Howey test. And then Attorney Farrell stepped in to provide an example. This tweet was the one that convinced me he doesn't know what he's talking about or have all the information. I mean, I have nothing bad to say about him as a person, and he does appear to be intellectually forthright. Simply said, I disagree with him on many of his points. And that's totally great with me. According to Attorney Farrell, Ripple is accused of raising $1.5 billion from investors by selling XRP on the open market. That is a sale of securities in violation of federal law. When cryptocurrency goes beyond being only an investment, the regulations for trading it on the secondary market may change. This is not a court case concerning that issue. Oh, that's only a tiny slip up there. Master of Laws Farrell, listen to this, he insists once more. Once crypto gains utility beyond investing, there may be different regulations for trading on the secondary market, but those aren't litigated here unless, of course, in this case. And to get right to the point, allow me to descend a level or two. Stephan Huber passed it forward. He has returned to this area. He then questioned and said, before responding to Attorney Farrell. What you're looking at right now is a clip from the SEC versus Ripple case that was either supplied or written by the SEC. And they put it in writing like this. They put out this hypothesis of embodiment. Those facts, conditions, promises, and aspirations are materialized in the XRP traded even in the secondary market. This day marks the beginning of that financial commitment. So, when lawyer Vigil claims that disputes over secondary market purchases don't arise, he's just showing how clueless he is. Actually, you couldn't be more wrong. To which XRP community member Stephan Huber rightly drew attention. The situation is what it is, period. And he seemed to sidestep the question. He diverted the conversation away from Stephan Huber's observation and began speaking about something else. However, it is what it is. It's interesting to see this for no particular reason. I enjoy these exchanges, and I find that there is more to learn and see when the exchanges are conducted in silver as opposed to gold, since yes, screaming matches can occur and some individuals get kicks out of that. As a result, I'm glad that grown-ups can be respectful and we can communicate opinions and ideas, even though I disagree with Attorney Farrell and the vast bulk of the stuff he says here. Quickly. But I think I should end this now. Please share your thoughts with me in the space provided below. I don't claim to be an expert on money matters. My words here should not be used as a basis for making any financial transactions. In the end, please like and subscribe my channel. See you later, bye.